This is involving Jennifer Gonzalez. Okay. I don't know how to be as succinct, but I'll try to be as succinct as I can. The court may recall that she has a PCS that's arising in the same incident that was over there. James Mount and Melissa over the Rick Court and I.
PCS means possession of a controlled substance. Already, the judge is hinting that this case could swing depending on how Jennifer's plea deal plays out. What do you think? Should possession charges always...
About 35, 45 minutes to try to decide what's going to happen here, and I'm trying to short circuit things. At the end of it all, we come out this morning, they're going to dismiss the PCS as long as she pleads here. They're allowing her to plead to a time served over here.
Not on the second. Sorry.
If you...
Not on the second.
That's...
No. If she wants a PTI, or if she wants a probation, okay. I think 30 is what we typically do on a second, but not time served.
Now, the first one was some time ago, Judge. Like
I understand.
Years ago.
I get it. And she had violations while she's on, right?
Well, they weren't violations that couldn't be excused or explained, because what happens is she takes Adderall. And so that's what I think the issue was.
No, I'm sorry. Not on that second. And it's not just you. It's just... I have before, and people have...
License, just a scooter. Judges often weigh public safety heavily here. After all, how much risk is she really if she doesn't drive? But does that excuse the behavior behind the charges?
Wrap their car on the pole.
So,
and
if I can, and it may or may not impact your decision, you know, she does not have a license, does not drive. Okay, she has that scooter that she's on that we talked about that's under 8 horsepower, whatever it is.
Is it one of those Costco scooters that you cannot take on the street?
Yes, you can't really get on the street with it, Judge. It's not one of those, and she has a license and has not had one. Okay, now I know there's going to be an imposition of a suspension of any license that she may have. I know that will be coming at her. The big issue with the probation, because that's one of the things that we first had talked about. She has to take care, and she's the sole provider for an elderly father. She doesn't drive, is unable to drive him back and forth and everything, but he depends like 100% on her. Now, my concern with the probation, and it was the thing that we kind of tossed about yesterday, is if she's forced to be in a position to make a decision of doing something for her dad versus appear for a urine test or appear for an office visit or something like that, she's going to defer and say, I'm going to take care of my dad. My dad's life means more than me reporting.
Probation will never interfere with anything that someone has to do for work, caring for another person. They will always work around. So if she gets called in for a drug test, all she has to do is say, hey, I can't come, you know, I can come tomorrow. They're not going to give you grace something reasonable the next day, perhaps a couple hours down the road, but they're never going to leave you high and dry to where they're going to do anything like that. I can allow, if she does well, after the first couple months, I can allow virtual reporting as well, so that she can report via Zoom, you know, if she's doing well. She will still have to, you know, I mean, she's going to have a guardian interlock, right? Because that's what we do on all probations, especially on the second. So
but she doesn't have a victim, doesn't drive, doesn't have a license.
She'll have a portable. There's a monitor on her.
Can I have her come forward?
Sure.
Come forward, since I was, you know, mind.
She's got a monitor ankle, and I'm paying for it now, right?
And it is killing her leg.
We'll take that off. We'll give her a portable device.
That has to be modified because it doesn't look good at all.
Her looks is the least of my concern.
It's painful, Judge. What I'm saying, it's painful.
Hello, Judge.
Hi.
How are you doing today?
I'm doing great. How are you?
Good, sir. Thank you.
What we had discussed, Judge, just so in the interest of full disclosure analysis we're talking, Marissa had agreed to have a plea to the DWI probation with the terms, including the treatment that's been recommended by the TRAS and all this type of stuff, which we had agreed that would be one of the ways to resolve it. And that would still have them dismiss the PCS. But once we talked about the the idea of setting her up for failure, if you would, I wasn't comfortable that she would be able, or this court might even be able to accommodate issues that would arise because she couldn't either.
A second DWI might not just mean probation. It could elevate the case to felony status. That's life-altering. Losing rights, job opportunities, and possibly...
You can always accommodate. Always. There's never a way that we can't. Never doesn't work in our vocabulary. And the thing that I want you to understand is that I don't, you now, once you plead, if you plead to this, it's going to go on your record. It is now a second offense. And the last thing we want is for you to graduate to felony status to where you're looking at 2 to 10 in the penitentiary.
Absolutely.
Right?
Yes,
And I want to make sure that you understand that there are consequences to behavior. You need to understand that if you ever get in a car, you smell like alcohol, you smell like dope, they're not going to care whether you're spilling, fall down ass drunk, where you've urinated yourself, whether you're vomit. It doesn't take that for them to file a felony charge on you. Even the faintest smell of alcohol, the faintest droopy eyelids, the faintest sway in the wrong way, they're going to charge you with a felony DWI, and now you're looking at up to 10 years in prison. I, at all costs, want to make sure that that doesn't happen. And in my experience, what I've seen...
Avoid a felony at all costs. Felonies follow you for life, far beyond the courtroom. What do you think? Should avoiding a felony be considered a win?
It never works out well. And I don't think that a time served on a DWI second is appropriate. I understand that you may take care of other people. I understand that you may have life issues. Actions have consequences. You not only have this DWI second, but you also have a felony possession of a controlled substance. He's worked a tremendous deal where they're going to dismiss the felony case. I'm going to tell you now, anytime you can avoid a felony, you're winning. Anytime, it doesn't matter. Because once you get that felony conviction, I cannot tell you how many doors that closes. And not only just from potential work, but I'm talking issues with the state, being able to get state resources, funding for things like food stamps, perhaps lose the right to vote. It really closes a lot of doors. And I want to make sure that that doesn't happen, So,
Judge.
we usually, now this is a second, you, by law, must do 5 days in jail as a condition to probation, right? I don't know if you guys have worked out an agreement where they're going to waive that and plead it down to a first, thereby waiving the jail time, but there's mandatory 5 days in jail as a result of this. That's what you need to understand, which is the other consequence of this. Now, if they're willing to do that, I'm certainly okay with that, but time served. And the probation, if you do well in the beginning and you show us that we can trust you, we will allow you to do virtual reporting through Zoom. But we have to know that you're going to do well, there are not going to be any issues, and most importantly, you're not going to use.
Absolutely.
Because that's what matters.
Yes, sir.
All we're trying to do here is make sure that you don't take a life on the road, so that you have enough of a crappy experience here that 15 years down the road, when you're placed in a position where you're intoxicated out there, man, should I get this car? I had such a miserable time in court with that Judge Fleischer. God, I never want that experience again. That's the idea.
Yes,
because
sir.
I want you to remember me 20 years from now when you're in a position of vulnerability where you make the right decision.
Absolutely. Yes,
And
sir.
hopefully with the probation, we get you to understand.
Absolutely, sir. I agree. It's fine.
Now, you have a probation officer, right? Your probation officer is always willing to work with you. If they call you in for a drug test and you're in some kind of situation where you can't, you let them know. We will give you the line to Shatoria here. She's absolutely an angel, is always willing to help you out. We can give you a direct access to her. If you have a problem, call us, call me, call her, and we will work something out.
Sure.
But there's never a way that we can't work something out. There's always a way. There's always a way. Always.
Yes, Your Honor.
Okay?
Yes, sir.
Give me a minute or two to talk
No
to
rush.
Mike, Judge.
No rush. And I mean, your case, Mr. Knowles, it's only what, like 140 days, right?
We'll have it over with today, Judge.
You don't have to.
But I think we're at that point. So I think just a little conversation, I think we should be able to get.
Okay. For sure.
And I appreciate it. Thank you.
Thank you, sir.
Monday morning, and his bond is gone. No second chances. That's the cliffhanger, the moment that will decide whether the story ends in freedom or behind bars.
Interfere.
It can, Judge, but I mean, the Scram device itself has an environmental tampering test. Like it will, the Scram device itself does a test internally to see if there are environmental factors that are affecting the Scram device. If there is an environmental factor that has affected it, as in he's a painter and there's some sort of paint that's got alcohol in it and it detects that, it will notice that it's not from sweat and it will not accept that as a TAC reading. In this case, it's not what it shows. There's a confirmed tamper event for about 12 hours and there is a confirmed TAC reading, but they can't actually confirm it because something was either stuck in the leg or it was removed entirely. So to me, this is a clear tamper and it meets the range for a tamper. It wouldn't even show that it's a tamper if it didn't meet the criteria range that Scram identifies.
Ricardo, he's saying it's a 12-hour tamper that could be. So are you telling me that it could not read his leg for 12 hours?
So it was reading and it read at that spike, and they won't state the actual level due to this.
Well, I understand that.
But the duration of the tamper was stated as 12 hours and I believe some odd minutes. So it wasn't able to either get a reading or get an accurate reading during that entire duration.
Did he have something in his leg? Like, I mean, a piece of paper in between his ankle and the device.
I mean, he very well could have, but there's no way of knowing, of course.
But the time is the biggest concern, Judge. If it's like, oh, it shifted on the leg and it couldn't detect sweat for a little bit, that's not a tamper. This is a 12-hour thing. It's clear that he's doing something to tamper with the device.
Ricardo, what say you?
Judge, I would ask how Michael knows the information that he is stating. How does he know what a tamper is considered? Has he been even trained by the Sentinel people? Why is he making these representations as fact? I would ask.
I'll tell you, Ricardo, I've done around 12 11B hearings, all of them successful, where I had Ronald Grant come testify about what the Scram results are, how they are, what they do to get to the results. So I've done multiple hearings regarding Scram devices, Ricardo.
Thank you, Michael. And that's what I'm asking for, Judge. I would ask for a hearing to have somebody come and testify. That's all I'm asking for. Not have Michael testify.
Why isn't he here, Ricardo?
Judge, I got notice of this yesterday when I saw the email in the afternoon. I tried to move this to next week. After I was told it wasn't going to be moved, I made contact with him and let him know what's going on. I don't want to say why he's not there today. I'm in a position where I need to make representations to the court, and so I'll just leave it at I let him know that there's a court setting today, and the issue is notice. I mean, I let him know like at 5 in the afternoon yesterday, Judge. I mean, we got notice of this yesterday, and he's expected to show up today during the holidays.
Have the person come on Monday to test.
Tampering with a Scram alcohol monitor. That's like waving a red flag in front of the court. Question for you. Does tampering prove guilt? Or could it sometimes just...
Do you want a case notice?
Do we have to subpoena them, don't we?
Yeah, it'd be Ronald Grant, Judge. He's the one that comes and testifies. And
Do you mind subpoenaing him? Can you?
to come
Monday.
Monday, I don't know if he would respond to it, Judge. I have a personal relationship with him. He might, but I mean, it's right after the holiday, so I don't know if he would on such short notice.
Can you reach out to someone to come on Monday so we can figure out, is it a true tamper? What's he doing to the device?
Yes, Judge. Let me have John see who has a